As many of you know, I'm Shanna Welsh-Levin, your Southern California real estate attorney with SoCal Realty Law. Here at SoCal Realty Law, we protect real estate investors and real estate professionals. I have been a real estate attorney in San Diego for 18 years now. We're going on 18 years. It'll be official in December. And I've been a California realtor for about 16 years. I also am the president of a nonprofit called Amicus, and we are building emergency sleeping cabins for women and children and women with children who are in danger of homelessness. We have 6 cabins that we've built in El Cajon that are nearly finished, and hopefully we'll have a move-in date for the women and women with children in September. So fingers crossed. It's been 6 years of advocacy on that project, and I'm really excited about it. I also help to write some law. I'm always interested in doing something new and unique that's never been done before. And so I'm always looking to get in on new projects that we can move the ball forward and help improve our community. In April 2020, my firm decided that we wanted to become a resource for our community of real estate professionals by doing these monthly webinars to keep landlords, property managers, and other professionals updated and aware of what's going on with the California Eviction Moratoria and landlord-tenant laws in general because of all of the changes. We've had changes to the law monthly or every 3 months or 6 months ever since April 2020. So this has been a great practice for both me and those of you who attend to stay updated on something that's been very dynamic. This is our Landlords Need to Know webinar series. Also, SoCal Realty Law assists people who are cheated in real estate transactions. We represent plaintiffs in real estate fraud litigation. We offer a full array of landlord services for both residential and commercial landlords. We do not represent any residential tenants, and we do occasionally represent a commercial tenant. We also handle quiet title actions, easement and boundary line disputes, and we offer flat fee real estate transactions. I tell you here that I'm a realtor, which sometimes that triggers the thought, oh, I sell real estate, but I don't sell real estate. I use my license because I use the California Association of Realtors forms. I participate in the Legal Affairs Forum and try to stay updated on all sorts of realtor information. One other thing we're seeing a lot of lately are property tax assessment appeals, and we do handle those on a regular basis as well. I remind you that the information I'm giving you today is not to be considered specific legal advice relating to any particular case or set of facts. This is just general information. And if you have specific questions for a situation that you're dealing with, I encourage you to contact our office and we will set you up with a strategy session or whatever is appropriate. So today's webinar will be back to basics, frequently asked questions, and an update on the California Eviction Moratorium. We will go over the moratorium update as well as do I follow state laws or local laws if they conflict, and why are these laws constitutional? How does inflation affect rent? Why is it so hard to evict a bad tenant in California? How do I draft enforceable notices? What if I do them wrong and need to withdraw them? Can I increase the rent? And how does eviction work in California? Also, I invite you to think of other frequently asked questions that you would like me to answer. If you think they're frequently asked, please put them in the chat. I will, as the moratorium winds down, I plan to do more of these kind of back to basics type of webinars. So first frequently asked question, what is the status of the COVID eviction moratoria? Meaning there are multiple eviction moratoriums, moratoria if you've taken Latin. The California statewide eviction moratorium expired after June 30th, 2022. Now, it's nice to say it expired. It still lives on in certain ways. We'll talk about that. But that includes the California Tenant Relief Act of 2020 and the COVID Rental Housing Relief Act of 2021. But we still have new and old local eviction moratoria that remain in effect or have been brought into effect since the statewide moratorium expired. In particular, I'll talk about the city of San Diego and the city and county of Los Angeles, but there are many others. So with regard to the California statewide eviction moratorium, the Rental Housing Recovery Act of 2021 required landlords to apply for emergency rental assistance prior to filing an eviction lawsuit. And that would affect any eviction for rent through June 30th, 2022. And arguably, it would still affect any of those lawsuits, especially when we're filling out the forms to file an eviction. But the fact is that those emergency rental assistance programs are out of money, so that requirement is obsolete and the court knows it. So when we do it, we are just basically complying in form only if that eviction relates to rents that were due prior to July 1 when the act expired. Now, if we run across a landlord who is trying to evict a tenant who filed an application prior to April 1st, 2022, but they haven't received a decision on that application, so that application is still pending, that tenant would still be protected from eviction. So we need to address that if it occurs. We don't currently have any of those situations, but it's important to note that's part of what lives on is, those, if any of those applications were submitted in time and haven't been responded to, then that is a concern for any landlord. When we issue notices to the tenants that relate to rent that was due prior to July 1, 2022, there's a special notice from the state of California that has to be included. And also there's a provision that I have yet to see a specific application. I think in Los Angeles, there's a specific application, but I haven't had any of these cases. Basically, if repayment of the past due rental debt must begin, it must begin no later than May 1st, 2022, which already passed, and the repayment must be completed no later than May 31st, 2023. Okay, I'm giving you this slide because I really like this slide. It is a visual depiction of different notice timelines, and it shows you when we would have to use the old notices. So even though this moratorium has expired, if you have a tenant who hasn't paid rent dating back to 2020 or most of 2021 and some of 2022, there is very specific language that you need to include in the notices. And we have different language for instance, there's the protected time period, talking about these segments in blue, March 1st, 2020 to the end of August 2020, protected time period. There's different language for notices relating to rent in that time period than for the next time period, the transitional time period, which is September 1st, 2020 through the end of September 2021. And then we enter into this recovery time period from October 1st, 2021 through the expiration of the California moratorium, which was June 30th, 2022. And special language applies depending on when the rent involved in the notice. These would be notices to pay rent or quit, depending on when that rent was due. So you might serve 3 different notices to one tenant because the language has to change. And that language is this notice from the state of California. We would still potentially have to use these old hardship declarations with the protected time period and transitional time period, although we really haven't seen those for a long time because those all deal with most of 2020 and most of 2021. There is a provision in the law that says that when you issue a notice to pay rent or quit, you're only entitled to go back 1 year. But because of COVID, that law was told, meaning that it was extended and you can go back more than 1 year for COVID-related rental debt. So there are some really specific things that we need to consider when a landlord needs to begin the process of an eviction. So as far as new ordinances, the city of San Diego has taken advantage of the fact that a restriction existed in the statewide moratorium and has now expired. So that provision prevented a lot of the local governments from doing their own eviction moratoria. And so now with the city of San Diego, we have this local moratorium that is dated to end September 30th, 2022, unless it's extended by the city council. And it provides that if you're going to withdraw your property from the residential rental market, you have to give 6 months notice to all of your tenants. If you have multiple units on the same parcel, you have to give 6 month notice to all of the tenants. You can't just do one unit. It has to include all of the units on the parcel. Because of the current expiration date, sometimes I suggest that we wait it out and see if it expires, because maybe the landlord only needs to do, after it expires, maybe the landlord would only need to do a 60-day. And so you would beat the 6 month timeline by waiting till October to start your notice period running, because you'd be within 6 months when your notice ends. If you do a 60-day on October 1st, that would end at the end of November, and you'd be able to file in December. Whereas if you file a 6 month, if you serve a 6 month notice on your tenant today, then that would not expire until, I think, February 2023, if I'm doing the math right. Okay, so the second bullet point is when we need to get the tenants out of the premises due to construction work. Within the city of San Diego, the construction work that is the subject of your notice must be necessary to comply with a government or court order that necessitates vacating the unit because of safety or habitability, and where the tenant can't stay because it would severely threaten their health and safety. This is slightly different for units that are not in the city of San Diego, but are subject to the Tenant Protection Act of 2019, which defines a substantial remodel slightly differently. The substantial remodel that is in the Tenant Protection Act is that the remodel cannot be reasonably accomplished in a safe manner with the tenant in place, and it requires the tenant to vacate the residential real property for at least 30 days. It has to be relating to replacement or substantial modification of any structural, electrical, plumbing, or mechanical system, and require permits from a government agency. So that's a bit easier to meet the burden of the Tenant Protection Act than to meet the burden of the City of San Diego ordinance. But the City of San Diego already had its fair renter ordinance, which restricted, for a tenant that had been there 2 years or more, the landlord could only terminate the tenancy due to the need for construction after having obtained all necessary permits. And then they seek to recover the rental unit for the necessary repair or construction when removal of the tenant is reasonably necessary to accomplish the repair or construction work. So that provision does not have the health and safety language in it. So currently it has to be, in the city of San Diego, necessary to comply with government or court order that necessitates vacating because of health and safety. Very narrow reasoning. Now the last restriction on no fault evictions in the city of San Diego is the 90-day notice for landlords or the landlord's parent, grandparent, child, or grandchild to occupy the rental unit as a primary residence. Usually that's a 30 or a 60-day notice. It's now a 90-day notice, and those are the only 3 no fault evictions that can go forward in the city of San Diego right now. Any other no fault type of eviction. No fault meaning it's not the tenant's fault for the eviction. Anything outside of these three cannot go forward in the city of San Diego right now. So what do you do if you've already issued notices and they're wrong? They don't comply with this and your property's in the city? We recommend that you withdraw all prior notices in writing. So you issue a document that states the landlord hereby withdraws all prior notices that have been served on the tenant. You would want to specifically identify which notices you're referring to, and then you would issue new compliant notices with these new timelines. So you might lose significant time, but it's better than paying to go to court and losing and having to do it over again, and maybe having to pay the attorney's fees of the tenant, maybe even getting sanctioned by the court. You could go forward and argue and hope that the tenant doesn't know their rights or doesn't get an attorney, but we don't recommend doing that. The city of Los Angeles has renewed an eviction moratorium based on non-payment of rent. And this is the one that had to be renewed after the statewide moratorium expired. So in the county of Los Angeles, not the city, but in the county, as of July 1, 2022, they renewed the prohibition on evictions. So they prohibit evictions for non-payment of rent due to COVID-19 financial hardship, but only for households that have an income at or below 80% of the area median income. But the trick here, what's interesting to me, is that financial hardship is determined by the self-certification provided by the renter. So there's not a very strict standard for how to qualify for this restriction. And it applies to rents that were due on or after July 1st, 2022. Notice that that's directly after the statewide eviction expired. Also, in both the, eviction is also prohibited countywide in Los Angeles if it's based on no fault reasons. There are limited exceptions for the owner to move into the premises as primary residence. You also can't evict if it's based on nuisance or unauthorized occupants or pets. This ordinance protects tenants from anti-harassment and anti-retaliation. So this is a pretty major development in the county of Los Angeles. Honestly, we don't take evictions in Los Angeles unless, I mean, really, we don't. We refer them to attorneys up there because it's a whole different world up there. There is also a rent increase freeze for all rent stabilized units in Los Angeles County's unincorporated area. So outside of the city of Los Angeles, you cannot raise the rent if you're in a rent stabilized, if you own a rent stabilized unit. Okay, so that's pretty major. The next frequently asked question is, do I follow local law or state law? So as you've seen, there are all these new local laws that may conflict with state law that now says you're not restricted, but the local law says you are restricted. The state restrictions must be followed first, but if the local restrictions are more restrictive than the state, then you have to follow the local restriction. So the state allows local governments to issue rules that are more restrictive than the state rules, but you can't go the other way. So if the state says we have an eviction moratorium and the city wants to say, no, we don't, that's not going to work. You have to follow the state law under that circumstance. And I get the question a lot, why isn't all of this unconstitutional? Why, as a landlord, why as a landlord am I being restricted from eviction by the state or by the city? Unfortunately, it is because of the police power that's given to the governor of the state and to the mayor and to the city council If they feel that these restrictions are necessary for health and safety of the public, to protect people from COVID, or to because of the housing shortage, to protect people from eviction, then they can do this. And certainly constitutional challenges can be filed. It's not my area of law, but I have seen these constitutional challenges in the past, and unfortunately, they don't work out on behalf of the landlords. Generally, the court will uphold the restriction because of the police power and because they are mostly temporary. Next question, why is it so hard to evict a bad tenant in California? I hear this one a lot. Why does it take so long? Why does it cost so much? Why is eviction so hard? Why do I even need to go into court to evict this person from the property that I, the landlord, own? And I totally get it. It really does take a long time. If the case goes to trial, it's very costly. We spend a lot of time making sure that our evictions succeed. We can't guarantee results, but what I say is that we set up every case to win, and we give them a high chance of winning in court. And so if we do have to go into court, we do everything we can to ensure that the landlord will succeed, or, you know, or advise the landlord otherwise. If we think it's not going to work out, then let's take another tactic. So the truth is, when it comes to kicking people out of their homes in California, California has very strong tenants' rights. There is a very serious housing problem in California. It seems like there are not enough rental units and homes for people to live in the areas where people really want to live. And so the strong tenants' rights are a response, and in part to that. So my response to this question is to focus on what can landlords do to avoid evictions. And if you end up with a bad tenant, what can you do in advance of that tenant coming into your property to make it a little bit easier to get the tenant out if it becomes necessary? So a few rules that you can follow. Number one, don't delay. As soon as the tenant is not paying, or they're breaking the rules, or they're raising red flags, get a legally valid notice served on them and get professional help. Gather evidence to support the issues. Make sure that you have your accounting of the rent that hasn't been paid, or the contact information for the neighbors or the other tenants who have observed the behavior. If there's illegal conduct, get police reports. If the tenant is breaking rules other than just not paying rent, like they are causing a lot of disturbance, you need to make sure to contact and gather all of that contact information and get the reports, get the photographs, whatever you can do to make sure that you have a complete file before you proceed with an eviction. Because once the case lands on my desk, I accept the case or reject it based on whether I think I could win the case if it went to trial. And if I think that we just don't have enough evidence, then I might say, well, we've got to wait until we have more information. Also, communicate with your tenant in writing if possible, including emails and text messages. We can use emails and text messages in court, but be careful how much you put in writing, because you can say things that are not in your best interest and hurt the chances of succeeding at trial. At the outset of the tenancy, it's very important to have a detailed California lease agreement that is updated annually if possible. Make sure that it's signed by the landlord and the tenant, and that the tenant is provided with a copy. I also recommend that the landlord have an addendum to their lease that states their own rules for the tenancy. If there are specific things like hot tubs, gates, keys, different things that need to be addressed that are specific to the property. And make sure to run the whole lease, including the rules and regulations, by an attorney to make sure that it's in compliance with current law. and not violating any fair housing laws or other kinds of laws that might apply. Always take a thorough rental application from the potential new tenant, get permission to run a credit check, including an eviction and judgment search, and most importantly, call those references. Pick up the phone and make sure to touch base with any references. A tenant that has no references has a red flag, because where have they been living? I mean, I guess if they've been living with their parents, that's one excuse, but it's important to make sure that you've spoken with some references. And for a new tenant, somebody that you, for instance, somebody who's been living with their parents, they have no rental history, you can start a tenancy with a term of less than 1 year, 11 months, 8 months, 6 months. And that gives you a trial period to get to know this tenant a little bit before they hit that 12-month mark. For those properties that are subject to the Tenant Protection Act of 2019, that's our AB 1482 law, once you get to that 12-month mark, then all of the just cause eviction requirements and the rental relocation assistance requirements kick in. So if you do just 10 months or 11 months, that gives you a chance to do a 30-day notice, and depending on where the property is located, you can, whether there are any other restrictions, you can probably do a no-fault eviction without requiring any just cause prior to the 12 months. All right, so we have some resources for landlords. These are, I'm giving examples. I'm not specifically saying that you must or you should only use these, but these are examples of services that if I am asked, this is what I know about and recommend. Being a member of the California Apartment Association provides a great deal of resources. There are different levels of membership, and they keep their website well updated. They've got lots of articles and lists and forms on there that are really useful. Sometimes a landlord doesn't know how to check credit. I think that there are websites out there with really nice software, such as Equifax.com, where it's a two-sided website. All the landlord needs is the name and email address of the potential tenant. They fill out a form online, and then the tenant gets an email asking them to fill out their private information and pay the fee for the credit check. Now, despite the convenience of not having to ask the tenant for their private information, I still recommend getting all the private information, including social security number, on a rental application. And that is because in the long run, if they don't pay the rent and you have to collect, you'll want that information to help you collect the rent. Also, the free resource will be a solid rental application form, and I will add questions that you can ask the references. I always feel a bit stymied when I have to interview someone because I just don't know what to ask. You know, hey, how you doing isn't going to cut it. So some specific questions for the references will be helpful to you and get the ball rolling so you feel confident making those phone calls. There are a lot of softwares that are helpful for servicing rent. It takes some of the element of the human element out of the collection of rent, and it also helps you maintain an accounting of the rent. So apartments.com is one such website that provides software. There are many. I recommend reviewing a few and seeing which one works best for you, but it's always important to have that extra help documenting the payments. And finally, I always recommend using a licensed real estate professional to manage your property. If you are interviewing real estate professionals to be a property manager, definitely use Google, and in particular, go to dre.ca.gov, that's the California Department of Real Estate, and check their license number. A licensed real estate professional is required by law to include their DRE license number on all of their advertising. But even if they don't, you can still look them up by name and make sure that their license is in good standing. You can also see if they have any discipline on their license, and you can read all about it on there because they post a lot of information if there's discipline. Next, FAQ, how does inflation affect rent? If you were with me in June, I had a very special guest, Miro Kopik, talk to us intelligently about inflation because I didn't feel qualified. And in the long run, I mean, it was very helpful to speak with him and hear what he had to say. I thought that he was very knowledgeable. My takeaway was, I think, fairly simple, which is basically when inflation goes up, property owners' expenses go up. So property owners want to charge more rent to cover their expenses. Also, tenants' expenses go up. The cost of everything goes up: gas, insurance, goods and services. So tenants have to allocate their funds accordingly as well. When interest rates rise, landlords no longer have that option to refinance to lower their expenses because the interest rates become higher than what they already have. And then this all comes to a head if we hit a recession, because in a recession, jobs and wages stagnate or go down. And then the question becomes whether we are in a recession. So a recent article published by Newsweek states that determining whether the US is actually in a recession can depend, at least in part, on GDP numbers. GDP is the total monetary or market value of all the finished goods and services produced within a country's borders in a specific time period. And that time period can reflect a fiscal quarter or a full calendar year. So a recession is, quote, a significant, widespread, and prolonged downturn in economic activity, unquote. And that's a quote from Investopedia. A popular rule of thumb for determining whether we're in a recession is 2 consecutive quarters of GDP decline. In the first quarter of 2022, the GDP decreased, meaning it declined, at an annualized rate of 1.6%, following a 6.9% positive increase in the fourth quarter of 2021. So we had positive, then negative. That's according to the Bureau of Economic Analysis. But then, let's see, I may have failed to copy some of it, but we just had a second quarter of decline in the second quarter of 2022. Despite the rule of thumb, the second consecutive annualized decrease in the new GDP figures that were just released in July doesn't necessarily indicate a recession. So we're not officially, according to this analysis, we're not in a recession yet. That's because there are other factors like the state of the labor market that may also be considered. So it's really a balance of goods and services and the labor market. This is my oversimplification of this, that determines whether we're in a recession. So certainly there's a lot of debate about this right now, but the overriding feel that I get from what I'm reading is that we're not yet in a recession. The concern is that if a recession hits and tenants no longer can afford their rent, rents could collapse. I don't really understand exactly what the result of that would be, but I think it would mean a lot of potential evictions. All right, so then the next question, can I increase the rent? Based on what I just said, you might want to consider whether that's a good idea right now. But the answer is, the question is, can I? Am I allowed to? And the answer is maybe. It depends on whether the property is subject to the California rent cap, which is the Tenant Protection Act of 2019. That rent cap is currently 10% as of August 1, 2022. Then we have the anti-gouging statute. The anti-gouging statute places a 10% cap on all residential property that is subject to a state of emergency and any extension of the state of emergency. We are currently in a state of emergency due to COVID, and now they're talking about another state of emergency due to monkeypox. And so the entire state is currently capped at 10% due to this anti-gouging legislation. And there's a difference between those two caps that I'll explain in a minute. Then we have rent control areas in Los Angeles, San Francisco, and other areas that are subject to the Costa-Hawkins Act. And in San Diego County, we don't have Costa-Hawkins, but we have Section 8 limitations, which are not rent control and not necessarily a rent cap, but does affect the answer to the question of whether rent can be increased. So this is just the explanation of why the properties subject to the 2019 Tenant Protection Act are capped at 10%. I will send out my slides as well with the free resource so that you could review that if you want. I have a few slides that analyze that whole area of law, which is interesting, but we're going to brush past it for now. The Penal Code Section 396 is the anti-gouging legislation, and it says no increase of more than 10% for 30 days after a proclamation of a state of emergency and during any extension. The connection or the difference really between this and the 10% under the Tenant Protection Act is that the anti-gouging 10% applies whether it's an existing tenant or a new tenant. So it prevents you from increasing the rent more than 10%, even if this is a brand new tenant entering into a brand new lease. Whereas the 2019 Tenant Protection Act allows you to increase the rent to fair market value if it's a new tenant. And the principle behind them is really why that difference exists. I forgot to mention, you cannot increase rent if you have a fixed term lease that does not include rent increases. Many commercial leases include rent increases, but most residential leases do not. A landlord cannot unilaterally increase the rent while there is a fixed term in place, meaning that you have, for example, a 1-year lease, and the rent for the 1-year lease is $1,500 a month. You cannot at month 8 just increase the rent. You have to wait until that lease is over, and then you can increase the rent. When we're not in a state of emergency, once the term of the lease ends, the lease would go month to month. So once the lease is month to month and we're not in a state of emergency, a rent increase of less than 10% can be done with a 30-day notice, but more than 10% requires a 90-day notice. And the way I read it is it's up to 10% can be done with a 30-day, and anything over 10% must be done with a 90-day notice. Oh, one more thing about the anti-gouging legislation. It's really hard to track the states of emergency and the declarations of the state of emergency and the extensions of the state of emergency. I don't know what to do as far as tracking those things. It's just, I'm going to put that out there. I assume that when we are done with the COVID state of emergency, there will be a big announcement of it. But I think it's common knowledge at this point that we're all still in that state of emergency. Okay, next one. How does eviction work in California? And this is basically the last FAQ that I'm going to cover today. And I want to just go through the eviction timeline because we are handling a lot of evictions through the court right now, particularly San Diego County, but some in other areas. And it's our observation that the timeline is currently delayed due to court backlog. In general, our eviction lawsuits are taking about 45 to 90 days after the notices expire, which means from the time that we file the lawsuit, file the unlawful detainer action, to the time that the sheriff gets out there to remove the tenant, it is taking 45 to 90 days. So we're recommending all landlords try to work with tenants and maybe try cash for keys or other sorts of negotiations You'll also find when you go into court, once you get your case to trial, the court stresses the importance of speaking with one another, the landlord and the tenant, and trying to work things out before going forward with trial. And that's just because they need people to get off of the court's docket so that they can handle the trials of the others. So the timeline should look something like this. You issue your notice to the tenants. If it's a, whatever kind of notice it is, it's a 3-day, 15-day, 30, 60, or 90-day, and now we have the 6-month timelines. Then you wait out that period of time, and once it expires, then the lawsuit can be filed. So we draft the paperwork, we get it verified by the landlord, meaning they have to sign it under penalty of perjury, and then the summons is issued by the court. The summons is a court order with the court's stamp on it, and then the court sends the summons back to us with also the conformed complaint, which currently involves 3 different forms. And they go out for service with our process server. The process server tries to track down the tenants, and depending on how the documents are given to the tenants, it triggers a calculation of how many days the tenant has to respond to the lawsuit. Excuse me. So we might personally serve a tenant and they get 5 days to respond. Or we might substitute serve a tenant, a defendant. And substitute service means that the lawsuit has been given to someone who has authorization to receive it on their behalf. So a substitute service, they basically get 10 days to respond. And if we can't find them at all, meaning they're just hiding in the property or they're not there anymore, but we don't know whether they're there, the process server can make a diligent effort to serve the lawsuit, and then they file a declaration. They give us their declaration of their efforts. They have to meet certain guidelines. We give the declaration to the court and we ask for an order to post. So that process turnaround is usually a couple of weeks to get the documents to the court and get the order to post from the court. The order to post allows us to post and mail the summons and complaint on the door of the property. So you post it on the door and you mail it to the occupants, and that completes service. From the date that the post and mail is completed, the tenants get 15 days to respond. And there's also an element of if there are unknown occupants at the property, there's a form that is served with all of these other things called the prejudgment claim of right to possession. That document is posted or handed over with the summons and complaint, and any unknowns who want to claim a defense or participate in the eviction lawsuit, they can file that with the court, and then they get 10 days to respond from when they go down to court and file that. I believe they have 10 days to file it, and once they file it, actually I think they have 5 days to respond from when they file it. So it's about a 15-day turnaround. So once the appropriate amount of time passes for the responses from the tenants, then the tenants either respond or they don't. If they don't respond, then we file judgment paperwork and a writ of possession with the court. The court turns these documents around. First we file a default. We take their default if they don't respond, and then we file the judgment paperwork. We kind of do this all as one package. The court is currently taking about 4 weeks to turn those default packages around to us. And once we get the judgment and the writ, then we take it to the sheriff, and the sheriff performs a lockout on their schedule, which can take about 2 to 3 weeks. They have up to 6 months to do the lockout. The writ is good for 6 months. During COVID, they were sitting on those writs for up to 2 months. But currently, I believe they're back to about 2 to 3 weeks. Or if the tenants do respond to the lawsuit, we request to set the case for trial. And then once we request it, the court must set the trial within 20 days of the request. And after a successful trial, then we file the judgment paperwork and the writ, and then that goes to the sheriff. A trial has a tendency to delay the judgment paperwork because after trial, the judgment paperwork has to go through the judge's hands. With a default judgment, it just goes through the clerk's hands, and the clerks process paperwork faster than the judges do. So another aspect of this is most of our evictions, we suggest that we do possession only, and you reserve the right to pursue rent. The reason is that a possession only judgment can be processed a lot easier and quicker through the court than a judgment that includes money judgment for rent. So that the reasoning for that is really just time. Typically, we want to get possession back so you can get a new tenant in there as quickly as possible. And so that's the timeline. How do you start an eviction? You would call us and we would help you get started. We'd set you up with our paralegal for an intake session. Then you'd speak with one of our unlawful detainer attorneys, and they would make sure that the proper notices are served, that we understand the status of the property, where it's located, what moratoria it's subject to, review the whole situation and make sure that we set the case up to win. And that's what I have for you today.